This material is made available to you by or on behalf of the University of Melbourne under Section 113P of the Copyright Act 1968. It may be subject to copyright. For more information, visit the University Copyright website.
And builders started getting their own people in to sign off on it. And and that came out in the... Yeah. So I rang him up after I said, geez, H, I said, you're not stupid, are you? You might be old, but you're not stupid.
Yeah.
He said, all goes back to that.
Yep. They palmed it off. The planning, the surveyors, they outsource
Everything.
them. Yeah.
Outsource it all.
Yep.
I know.
Yeah, it's worrying. Yeah. But they are also responsible for, they have standards that they respond to, these independent surveyors. Not all of them are dodgy.
No, they're not, as the guy said. We've got this building, I only have to look at a certain number of them.
Yeah. Yeah, it's just, it's the apartments, market that's seriously
I know.
because they're designed to make money.
Correct.
As soon as they will cut costs.
Correct.
Yeah.
And I tell people...
The margins are low, so...
Yeah. And I tell people, you're not paying market value.
Yeah.
Have a look at something that was built 3 years ago, and there's properties up. You can't get the money that they paid for it. So, come on. Have you ever heard of the hypothetical method? This is the profit they want to make. This is what they want to do. So, you're paying their profit for it.
It's just, we see townhouses go up around our suburb and look at how they're being built. It's like,
I know.
it's just shocking. Utterly shocking. Construction. We told you we built our home. We built our home.
You were...
So we moved in April this year. Until today, we're still dealing with a crazy neighbour on the other side. She's insane. She's alleging all sorts of nonsense. Apparently, when we demolished the place, she alleges that there was sonic boom level noise.
Sonic boom?
Yeah, that's sent off like our BS meters were ringing, right? And then she's now taken us. She went out before the Building Appeals Board because she took us to magistrate court for a so-called adverse possession claim because she was holding up our project. We just settled it. The lawyers said just settle it, just get rid of her. And we signed out, we got her to sign a waiver, and she did that. So we carried on building the project. Literally, her claim, and the certificate of title says the line is like that. The fence line that was built 6 years ago moved away from the certificate of title line into our property by at the most 20 centimetres over a course of like 1 metre. So the whole discrepancy was maybe like 2 square metres. Like we needed that 2 square metres of correction, and we signed off on it. We advised her of it like several months before the construction started and before we signed the builder's contract, right? We got a clearance and we're building the wall on the boundary, blah blah blah. She lost the plot like during construction. Like she just somehow thought that we were taking her land, and we're like, no, it's not. And anyway, so she was alleging like the fence that after all of that magistrate court, we got rid of her, we built it, and we agreed that the boundaries where the title says it is. She shows us this piece. She tells our guys, so our fence. So this is looking back into our property like that. Hers is here, ours is here. The fence post is here, and her fence post is here. There is a nail on her fence post here, and she says, "Oh yeah, that's what marks the boundary." So she's the whole country's knowing about it. So it accords with us saying right from the footpath there's a discrepancy of 8 centimetres. She just lied. The whole thing was a whole lie. And I was gobsmacked. And I went out that evening, and sure enough, the nail was there. She said, she was worried that we were going to get her to remove her post. We kept saying, we don't care about your post. We're not going to touch your post.
How strange.
So stupid. Like, and so she tormented us, delayed our projects anyways. We went out to build, and now she's back again. Like, she's alleging demolition works, and she's found a way. There was some towards the back of the property. We had a garage wall. No, it had a brick boundary wall, which had to come down. But before it came down, we put some temporary fencing because she had a pool on her side, and she used our wall as a. So, but that was basically the only protection was temporary fencing from a pool. She's using that now, and that's the only way an adjoining owner can sue us for damages for temporary works, right? When you normally think about temporary works, you think about shoring, all that sort of stuff. All this was like, honestly, just temporary fencing before for that wall to be hand demolished and fencing put back. She's now saying that is her avenue for now alleging that the demolition works, which got nothing to do with protection works. So we have to deal with this madness. Apparently, she stood before the chairperson of the building appeals board and said, I'm gathering. I tried to gather seismic data because that's how massive the concussion and the vibration is.
There's one sick woman.
And I was just like, so she's, her points of claim are due this Friday, and who knows what madness that we have to deal with. But just go and put an insurance claim. We've been telling you if it's legitimate, it's massive, great big structural damage. She has one photo. One photo. What do you make of that as a layperson?
She's nuts.
Yeah.
She's a vexatious litigant. She's just, and she got lawyers.
No.
She's doing it herself.
Yeah, and a crazy ex-husband who used to be a builder who built the double-story extension in a house, and we know that it's dodgy.
Well, there's something you can look at.
And there are no downpipes in a house. We just roof and just these gutters. When it rains, it just gushes down. And even claim, she says, that there's an underground drain from our property that is flowing into her property and causing damage. And I was like, perhaps the fact that you don't have guttering and, water's just spilling out onto your land when it rains.
Next time there's a really big downpour, film it.
Yeah, we have.
Oh, yeah.
It's just insane. We don't have to feel it. Like, it's just insane. Like, every neighborhood pool is cracking and dodgy pool is
And
cracking.
you know what? It just makes it so unpleasant.
And she's like garnered all these neighbors. And, apparently she's got up to 10 neighbors, like, going to, give evidence for her against seismic data, sonic boom. I'm just like, what alternate psycho reality are we living next to?
Yeah, that's exactly right.
Yeah, it was just, I think she's just lost the plot. She's just lost it, totally lost it. And we don't know how to deal with it. And she writes all this massive.
You just got to hope she doesn't die in suspicious circumstances.
Yeah, I don't know, yeah. So she went to Mexico for her kid's wedding and we're like, kidnapping. Nothing happened yet on
Just
so I'm getting a lesson in those garden variety fruit cakes that I misrode.
okay. Let me just grab my pen and my notes. Go and take a seat as they slowly make their way in. Make sure that's silent, which it ideas. You're right.
Yeah.
Okay. Lecture 2 of Binu's 3 lectures, and on contract administration predominantly. At the end of it all, we can ask any questions, and we'll then take a short break. Then we'll gather again and have a look at something. Did anybody watch Four Corners last week? No? Good. We'll watch it tonight. All right. It's about the construction industry and the high-rise apartments. All right. And we can have a chat after that. So I will hand you over to Binu.
Hello, everyone.
There we go. All right.
Okay. So today we're going to deal with contract administration. So this is just part 1, and next week will be part 2. The items that we'll cover off today are the role of the superintendent, security and construction contracts, the actual contract document itself and how you make those up and what that constitutes. We'll have a bit of a chat about construction site and a concept of subcontracting and novation. And finally, defective works and defect liability period, which brings us sort of towards the end of the life of a construction project. So, what is contract administration? So, most long-term contracts, other than just construction, there's a need for some mechanism to make those mutual promises work. So, you make promises right at the start. How do you make sure that those promises are actually kept? And how do you administer them? So it's basically a contract administrator who has the role of doing that. In Australia and under the Australian standard form, that person is generally called a superintendent, and the superintendent administers the contract and promotes the risk allocation agreed between the parties. And they do so via directions, and it's normally at their discretion, so they decide what goes and what doesn't. And it's normally the exercise of this discretion which frequently comes under scrutiny. So whenever they make a decision, one party is not happy about it. That's when you have disputes and claims and conflict. More and more you'll see in contracts these days that, you know, there'll be terms in that contract which basically says the superintendent is basically an agent of the principal, especially in larger contracts. So there's more of a sort of a loyalty towards the principal rather than the contractor. So don't be surprised if the superintendent administers the contract in favour of the principal. So the superintendent is not a party to the construction contract. What does that mean, not a party? Does anyone understand what that means? Yeah. Yes? They don't what? They do have to answer to whoever is paying them. So there's a separate contract between the superintendent and whoever it is who hires them. But they're not party to the construction contract because they don't... Yeah, so there's the construction contract deals with a promise between the principal and the construction contractor, the construction company. The superintendent is merely a third party that administers the promise. So they don't sign the contract. There's no consideration that flows, so they're not paid via the construction contract. However, the superintendent may be an employee of the principal, and there's probably a separate employment contract between them. Or alternatively, if the superintendent is an independent third party, then either the principal or the construction company or the contractor will hire them, or they'll hire them jointly. So they're not party to the actual construction contract itself. But nonetheless, the construction contract itself will call for a superintendent and impose duties
on the superintendent. So the sort of duties that you have in an AS form contract is normally duty to act reasonably and in good faith, and duty to act without delay. So these concepts, to act reasonably and in good faith, there are all sorts of interpretation of what that means. There's no clear legal position in Australia as to what good faith means, and again, to act reasonably, again, is up for interpretation. So it's grey areas. Is basically there are no sort of set principles on what that means. One way that lawyers try and circumvent the whole good faith, what good faith means, is they try and define that in the contract. But if there isn't a definition, a set definition, and parties don't really have a clear idea what that is or expectation of what that is, then you have to go to court to try and determine whether the superintendent has acted reasonably and in good faith. So you can already see that, that sort of grey areas is open for disputes and arguments, right? And duty to act without delay. So that's easy if there's time frames within the contract which says superintendent needs to do something within a certain number of days or a certain number of weeks. But if there's no such stipulation of time without delay, is again a grey area, right? So what you might think is a delay may not necessarily be what a superintendent thinks is a delay. You might think 24 hours, anything more than 24 hours is too long. And they would say, oh no, 5 business days should be just fine. So all these grey areas, you'll see in construction contracts.
Is there any case in the court that defines these terms?
Is there any case? Oh, there's no shortage of cases. So, as I said, it's one of those hotly contested areas, the superintendent and the fairness of their decision-making process or their actual decision itself. So there's a lot of ways that parties have tried to get around these problems. They prepare specific drafting in the contract which says superintendent should do this within such a time. So then you have removed the grey area of without delay. Then you might say superintendent is not required to make decisions to benefit one party or the other. So they're totally independent, and then you can argue about that later. So there's a lot of case law which brings into question a determination made by a superintendent. So that's an area for law students, just understand that there are potential grey areas. When you read a contract, look out for what is required of a superintendent in that contract. Perhaps one or more of you might end up being a superintendent 15 years from now on a project. Then you'd have to understand what your obligations are under that particular construction contract as a superintendent. So duties are also imposed on the superintendent by common law. So outside of the contract, we talked about the AS 4000 document that talks about duties that are imposed within the contract, but outside of the contract, common law also imposes duties on the superintendent. So you've got the case law, WMC resources and latent contractors, where there was this duty imposed to act honestly, bona fide, and reasonably. And then the John Holland and Mallorca project case, where there was this requirement, where the court enforced a requirement to act fairly, impartially, and to have regard to the interests of both the contractor and the principal. Generally there's this requirement that the superintendent has a duty of care to both parties, but sometimes you might find construction contracts actually move from that. So they'd be just be wary of it, and just that there are clauses in there that parties will say superintendent is an agent of the principal, owes no duty to act in good faith, and basically will administer the contract on behalf of the principal. And you know what that basically means is they're just a principal. They're not an independent third party or of any sort. So we've covered this. The construction contract will also impose duty on the superintendent to act in a particular time frame. I don't know if you guys have access to AS 4000, but Philip might sort of give you guys access later in the course to a standard form. And they are licensed, so you can't really just go and pull them out. But you may be able to see example of these clauses online. So the actions and the determinations taken by superintendent are generally referred to as directions. Sometimes these directions are verbal and they're followed up and confirmed in writing. So you're on site, the superintendent is there, you walk through site, they may tell you to do something and then they may send out an email or a letter to confirm it. Sometimes they don't, and then it's up to you as the project manager or an employee of the contractor to actually confirm that sort of directions. In some contracts, failure to comply with a direction by the contractor amounts to a breach of the contract. So that's basically a clear sort of clause in the contract which sets out that if you, contractor, fail to follow a direction, then it's basically a breach of the contract, and there are consequences that flow from that non-compliance. So who can be a superintendent? They're usually required to have a particular technical or skilled background that's relevant to the project. Why do you think that would be the case? Yep.
Because they have to make calls and decisions fine. So if they don't understand the project correctly, they make the wrong call.
Yep.
That's just
So that they're able to make the correct call on behalf of generally the principal. Yep. Or the contractor. So no point getting a superintendent who's only ever worked on building projects to become a superintendent on a tunneling project. Totally different, knowledge set. So you'd want someone who's actually worked in that particular sort of project. Okay, so no point getting someone who's only ever worked on tunneling projects to then go and build an airport, right? To become a superintendent in an airport project. So it's not unusual, I've said this, for a principal to appoint an individual from its own organization. In fact, it's very, very common. What's unusual is if a superintendent is appointed outside of the principal's organization. So as a superintendent, they must have a good understanding of the contract and the risk allocation the parties have agreed to. So what does that mean? Should have read the contract? Yep. If anyone should read the contract, it's the superintendent, right? So the day-to-day role of the superintendent, it usually includes, for example, assessment of claims for extra payment, so variation claims, extension of time claims, dealing with notification to risk events. So, for example, if you've got latent conditions, site contaminations, delays, site interface issues with third party and access to site, all the sort of problems that you'll see day to day on any project. Often, you'd have to call on the superintendent to make a determination or a decision. So basically, a claim under the contract, whether by the principal or the contractor, is often an attempt to reallocate the risk under the contract, and this is where the superintendent is an important party. They will basically try and ensure that these claims are legitimate, and if they are, then there's an entitlement that flows from it, and if they're not, then they'll just cut it down and say no. That's basically an attempt to reallocate the risk, and it's not matching the reallocation that's agreed to by the parties under the contract. So superintendents often prepare this thing called a risk allocation chart. It comes in many forms depending on how complicated the project is. It's something that you'll probably come across as, if you ever join a project and you start out as a superintendent, perhaps you may actually be required to prepare one. So it's just a tool. Unfortunately, I can't bring one out and show it to you guys because of all sorts of confidentiality issues. But look, they can be as simple as a chart which basically says this risk lies with the principal, lies with the contractor, tick, 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 where it applies, right? Or it can be as complicated as, quite an intricate little flow chart which talks about, if this risk occurs, how much time does this party have to make a claim? Then this party responds, what do I do with it? That sort of stuff. And often there's like links to the programs, the program for that construction project. So it's really entirely up to the superintendent on how they run that project. So the role of security is the next thing that we're going to talk about. But before I move out of the role of the superintendent, do we have any questions? Anyone ever thought of maybe that's something that you might do as a career path? Oh, one hand. Excellent. Why? Yes. Superintendent. Okay. And excellent. I've never had an ex-superintendent or a superintendent. So, what would your days be like on a project? Name the last project that you worked on as a superintendent.
Projects that I work on are quite small.
Yep.
But you do constantly have, you don't see in this bigger role allocation of risk being tried to be shifted on smaller projects.
Yep.
As they get larger,
Yep.
but yeah, it's
And so on a small project, what would your day-to-day sort of involvement be like?
it's more just like answering questions that they've got.
Yep.
On how they can't find, or they don't really look at the plans or the specification.
Yep.
Find the information all the time. Specification.
Yep. So problem solving.
Yeah.
Yep. So and basically it goes back to the fact that there's a real reliance on the superintendent having read the contract, right? And the contract is not just the general conditions; it's more the specifications, the scope, the sort of regulations that overlay on these sort of requirements for the project standards. So yeah, a lot is asked of a superintendent, regardless of how big the project is or how complicated or simple the project is. Even a house project, if you have a project manager who's ultimately the superintendent, they have a pretty full-on job, that from 7 a.m. to 4 p.m. it's constant. And they don't just run the one project, they run many projects at the same time. So yeah, it's a pretty intense kind of role. But, nonetheless rewarding, I would expect. So security in construction contracts. Were we all clear on what that meant? Security. Is it two Dobermans tied to a chain, barking away at the fence? No? What do we mean by security in construction contracts? Autopiloted drones that circle the site 24 hours 7.
With the provisions that ensure that the project is going according to the plan and inevitable quality and
So what is the security?
some kind of bond or monetary things.
That's right, bond. That's right. Bank guarantees, performance bonds, insurance bonds. So yeah, it's a product that basically the contractor will have to provide to the principal in securing its performance. So if the contractor does not perform, what happens? What do you think will happen? is the bond. The principal can call on the bond. So it's basically the role of the security is to secure the performance of the contractor's obligations under the contract. And it basically is money, right? It's a piece of paper that gives you access to money. And if, let's say, your contractor is not doing the job, you can call on the bond. There'll be very prescribed circumstances in which you can call on the bond, and the contract will state that. Once you call on the bond, it basically gives you access to whatever that money is. That is the value of the bond, and you can step in and complete the works. So is the sort of ideal intent of that performance bond. It's called a bank. It's a guarantee. It's a bank guarantee. So just to talk you through that, I've entered into a contract. You want me to build 10 stories of apartment block and it's worth $10 million. And you say, as part of that, so I'm the contractor, you say, you need to give me a performance bond that's worth 10% of that contract. So that's $1 million. So I, contractor, then go and visit ANZ Bank and say, I need a performance bond, a bank guarantee for $1 million. So they say, okay, they do a credit check, you're good for it. They give you a piece of paper which says, we hereby, blah, 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 agree to pay $1 million to principal, XYZ, upon demand in writing. And for that piece of paper, you give them some money. It's a product. You pay money for that, okay? You take that piece of paper, I give it to you. So you have this piece of paper which says, whenever I feel like it, under the contract, or whenever I am entitled to do so under the contract, I can take this piece of paper, go and see ANZ Bank and say, I'm calling on this bank guarantee. And what they'll do is have a look at it and go, okay, they write you a check for $1 million, here you go. Right? It sounds fabulous, but the likelihood of a principal calling on a bank guarantee, especially on large construction projects, is pretty low, right? Because the contract will be very clear on the instances on which you can actually make a call. And often these bank guarantees are so high in value that if you do make a call, it's pretty much you wanting to cause some sort of reputational damage for the contractor, right? Because their credit rating dies as soon as you make a call on that bank guarantee. In smaller projects, it happens more frequently, so the value is pretty small. So in larger projects, there are circumstances which you're sort of able to stop a call on a bank guarantee and things like that. So, it's a pretty handy thing to have as a principal, but with it comes a lot of responsibility also. So that's basically what a performance bond is. It's generally an on-demand, unconditional bank guarantee. Insurance companies sometimes issue that product too, and it's called an insurance bond if it's issued by an insurance company. So basically that's what a security is. So in smaller projects you do have retention sums, so that's basically security in the form of retention sum. It's wonderful. It's basically cash is king, right? So every time you make a progress claim, the contract will say that principal can retain up to 10% or 5% of that progress claim. So first progress claim in January, you ask for $1 million and the contract says you can keep 10%. What's that worth? What's 10% of $1 million? What? Are you joking? What's 10% of $1 million, guys? Pull out the calculator because you're embarrassing yourselves. $100,000. All right. They get to hang on to that and only pay you. Excellent. Yes, $900,000. That is pretty phenomenal, right? If they can hang on to 10%, because that's an instant guarantee that they have. They don't have to give you that money, but it hurts you as a contractor. Why? Why is that $100,000 so important to you? Yes, because you have other responsibilities. You're relying on that $100,000 to pay employees, to pay bills, to pay subcontractors, right? So you'll have to do the necessary calculations to ensure that you have cash flow in your business. So that's a pretty tight sort of way to deal with security. So in larger projects where your progress claims are the $1 million or the $10 million, 10% is actually quite a lot, right? So a cheaper way of doing that is just going and buying a bank guarantee, which will actually cost you a fraction of that retention amount that you lose in a month, right? So in small, like domestic building contracts, a homeowner who commissions a building, it's pretty expensive for them to go and buy an insurance bond or a bank guarantee. So they'll say, sorry, it's expensive for a domestic building company to go and buy bank guarantees. So they'll say, just take a retention. Yes. Depends on the value of the bond itself and the sort of credit rating that you have and the duration for which the bond needs to be alive. So if there's a time period, it's cheaper, but if it's an unlimited period, it becomes more expensive. So yes.
So this bond, from my understanding, is like insurance.
Yes, insurance.
Why would the bank only look at your credit rating, but not your ability to actually complete that project, like your business plan or your methodology?
All that goes into credit rating. So don't limit yourself. So they run their own credit checks on you, right? So it's a pretty big investigation that they would carry. So there's some research. So when you think about credit rating, it's not the credit rating that say the Dun and Bradstreet kind of like searches that you have. That they will do their own credit ratings to determine whether you can actually meet a call on that bank guarantee. So large top-tier construction projects, they have huge facilities to back them up, right? So they've got enough assets to cover a call on that bank guarantee. So imagine companies like Leighton, CPB, or even John Holland. They work across various states. They do huge projects, right? So every time they sign on a contract, a 10% or even a 20% bank guarantee is quite significant, and you times that by like 20, 30 different projects across the nation. They would have to have some serious credit facility with not just one bank, but several banks and several insurance companies. So yeah, so the credit rating check that goes through is pretty significant for top-tier companies. It'll obviously not be that onerous for a smaller company. But yeah, so, sometimes I think banks will say, you give us some level of collateral to cover that, where it's a smaller company. So who provides security? It's the contractor. And normally it's a precondition that, before you're entitled to make your first progress claim or within 10 business days of signing the contract, or something along those lines, you contractor need to ensure that you provide that security to the principal or the superintendent. So the forms of security, you've got the bank guarantee, which is as good as cash, and it is so because that piece of paper, you can go up to the bank and just say, yeah, I want to make a call. Retention monies, which is the traditional way of doing it, is basically you keep a percentage, an agreed percentage from each progress payment. We talked about what a bank guarantee looks like. It's basically a piece of paper that is issued by the bank, signed by the bank, and it basically makes a promise to the beneficiary, the principal, which says, if you turn up at my counter, make a call with this piece of paper in hand, I will pay you up to whatever the value that's stated in that piece of paper. So how does it operate? You provide the bank guarantee. Generally, bank guarantees work on the basis that you need to have one alive up to practical completion and another one that will bring you up to the end of the defects liability period, which is the final completion. So let's just say you're required to provide guarantee which is worth 10% altogether. So you'll go to the bank and you'll ask them for two pieces of paper. One is worth 5% and the other one is worth another 5%. And then you hand that over to the principal. At the end of PC, you'll say, okay, I've done everything. You've provided me with the certificate of practical completion. Can I please have one of the bank guarantees back? You take that back and don't tear it up, but pretty much it's done. They don't have it. They can't make that claim anymore. And you send it back to the bank and it's all cancelled. So you no longer have to pay to keep that guarantee alive. And then when you get past the defects liability period, whether it's 12 months or 24 months, a final certificate is hopefully issued and everything is done. Then, in exchange you get the next bank guarantee, and that's pretty much done. However, if parties are in dispute, bank guarantees are generally held. Okay? So sometimes a dispute occurs before the certification of practical completion, in which case the client will hold on to the full amount of the bank guarantee. Sometimes there's dispute after practical completion, so during the defects liability period, and they only have half the value of the bank guarantee because the other one they would have returned. But either way, it's still an incentive. It drives a certain sort of behavior. It's basically, I want to stop paying for that bank guarantee and I just try and resolve whatever issues that I have with the principal so that I get my certification and I get my bank guarantee back. Okay? So why do we reduce the security at practical completion? Why do you think it gets halved? Yeah, so basically practical completion is a recognition that the project is complete, right? Except for small defects. And it's you're basically handing it over back to the client and they will have possession of it, they can have access of it, they can do whatever they want with it. So it's a project is complete, hand it over. So the only thing that remains is to ensure that if any defects are discovered during the defects liability period, they want you to come back and fix them. So why is that worth 50%? The value of the project? The value of the security? Yeah. Yep, that's one reason. Yeah, so they could be, the quantum or the amount of defects could be small or could be quite extensive and over the course of that 12 or 24 months. So there's no real science as to why we split it 50-50, right, to tell you the truth. But it basically drives the fact that, it's sufficient skin in the game that keeps the contractor coming back to fix those defects and also to cover, there's no way of guessing what the value of the defects might be during that 50% and during that defects liability period. And if the builder just scarpers and is not interested in fixing those defects, then at least you have that money that you can call on and fix those defects yourself. So when can the principal enforce the security? So when can they actually call on the security? So the contract will normally state
But examples of that is basically when the contractor fails to comply with a notice to rectify defective works, where the principal removes the balance of the works from the contractor, so obviously non-performance, so we'll take it away from you, and I'm going to call on the security so I can pay someone else to do those works, or if there's a debt due or liquidated damages. So when do you think liquidated damages will apply? That's right. So you don't. That's right. So LDs apply, liquidated damages apply when the contractor fails to achieve completion by the date for practical completion. So the minute you fail to achieve PC, LDs will start ticking over, and often contracts will say that's a debt due, and if you can't pay it, then the principal can call on the bank guarantee to fund that claim. So I've alluded to this. The implication for the contractor, if a principal calls on a bank guarantee, pretty serious ramification. There's, your banks will be very, very concerned if a call is made. If the contractor disputes the basis on which the security is being enforced, there are very limited circumstances that you can actually stop the call, because generally the way the law has developed, they're called unconditional bank guarantees. So, there are very limited circumstances in which you can go to court and say, stop, don't pay. Often it's already too late. The call is made, the funds are transferred. In all likelihood, you could get an injunction preventing the principal from moving the funds. So you basically say, keep the funds in a locked account kind of thing, in escrow or something like that. And don't touch it until we resolve the dispute. Okay, so don't dissipate that fund, so let's just protect it. That's one way you could do it, but you'd have to move pretty quickly. As a lawyer, injunctions to prevent the loss of bank guarantees is pretty much one of the most exciting things that you can work on, because you'll get a call from the client, says so and so has made a call on our bank guarantee, we need an injunction, and you pretty much kiss goodbye for the next 48 hours of your life. Basically, you work around the clock to prepare all the paperwork and turn up in court. Generally, the turnaround is 1, maybe 2 days if you're lucky. Generally, the expectation is you're in court the next day, arguing the matter and making sure that no one, those monies are not lost. It becomes a real issue if you're dealing with foreign entities, and then they move those monies outside the country. And once that happens, then it's pretty hard to get it back.
What prevents from principal to just simply enforce this and get the money?
Nothing.
It's a bit scary and sounds unfair.
It is a little bit scary and it's a little bit unfair, but generally principals in large projects, they give you a bit of warning before they do something like that. I mean, they must really be upset with you, one, to make a call on the bank guarantee. Generally, you would have an inkling that they're going to do so because you're already in dispute and you're having a fight, and you know that your bank guarantee is in jeopardy, and you would have briefed your lawyers to be ready to go as soon as that call is made. Generally, you'd be having some pretty hard-hitting conversations with them to ensure they don't do it, but sometimes it happens, and when it does, you would already know that you're pretty much in the pool with the client, and it's just one of the consequences that you have to deal with. There's some really major cases that you'll find in Australia where, these sort of calls are made, and the value of the bank guarantee is pretty significant. They're multi-million-dollar bank guarantees, and they pretty much crush the company that provided the bank guarantee. So it's
Banks cause a bank guarantee, like termination of the contractor, or is this
Yeah, so termination of the contract, it's all rolled into it, right? So you might say you want to terminate the contract, but that still doesn't protect a call on a bank guarantee, right? So
How would you then work together after calling that?
you don't, you hate each other, you go to court. You cannot work, once something like that occurs, it's pretty much, it's like destruction mode. Yep, yep. So, yes.
Like the bank, so the principal says, I'm calling on the bond on the basis of this. Does the bank look at it, or does principal says such thing?
That's a very good question. 20 years ago, there were circumstances where the bank guarantee itself will outline the instances in which you could be entitled to make a call, and you'd have to prove, the principal would have to prove that that has occurred and they actually have a right. But that became too hard. So they've now evolved this idea of a bank guarantee to an unconditional bank guarantee. So there are no conditions attached to it. All you need to do is turn up with the actual document. If you have the original document, you're good to go. You don't have to justify it. You just say, here's a document. I represent the company who's the beneficiary here. You'll do an ID check. You're like, okay, here you go. That says 2 million. Do you want the full 2 million? No, actually, I just want 1 million. Hand it over. Yes?
Would most contracts not have a clause in there in which you have to issue, the principal have to issue notice or something like that?
Sometimes, but see that sort of detracts from or dilutes the efficacy of being able to just go and make a call, right? So the contract will say make a call, you know, in terms of there's a breach, right? So the clear reasons within which you can sort of enforce or a security, and you know, if you do it wrongfully, then yes, you can take them to court and sue them, right? But the first thing to do is to make sure that they don't spread the money or lose the money, and then you can't get that money. So the initial risk is to ensure that that money is protected, right? So that's what we do generally. Long time ago, you could have an injunction to stop the call, and then that evolved to stopping or an injunction, injuncting the bank from paying out. So if you had sufficient notice, you could potentially have that injunction, but again, you'd have to prove. It's a pretty difficult thing to prove or to prevent. And then the next thing you can do is once a call is made, you lock down that money. You just get the principal not to handle that money, just to leave it alone until disputes are resolved. Okay.
Those things are a lot harder with retention.
Oh, retention. Yeah, retention is retention, right? They hang on to the money, it's theirs. So it's more a contractor claiming that money back. So it's a contractual right. It's not necessarily a call. So you don't even have it. It's there. It's with them. So it's more of sort of getting a payment out on those retentions that you'd be arguing. Yeah, so it's a different argument in terms of retention. You never had that money to start with. It's merely a contractual entitlement that you'll have to enforce later. Yep. So, yep. So there's this case called the Anaconda case. It's one of the more sort of exciting cases. I sort of every year I sort of think about if there's other cases that I can think of. But anyway, so here we are, 20 years? The parties. So there was Anaconda Operations. They're the owner and operator of $1 billion nickel and cobalt processing plant in WA. And then there was a French company called Fleur Daniel. And under the contract, FD provided security in the amount of $45 million. Pretty full on 20 years ago. $45 million is quite a lot of money. So just to give you an idea as to how quickly things progress in these sort of stuff, it's quick for most lawyers because anything before the court takes forever, right? So 21st of September, the principal makes a demand on the security and deposits the money into its own account. $45 million. That would be a massive day for them. And then the very next day, Fleur Daniel goes to court. So this is what I mean about them having already, they probably have already instructed their lawyers, like any moment now this is going to happen, which allowed them to be in court the very next day. They sought an injunction from the Supreme Court of Victoria restraining the principal from further dealing with the proceeds of the security. They obtained that injunction, so the court took 8 days to obtain that injunction. Several months later, the principal appealed the injunctive order and they won, which basically meant they could do whatever they want with that $45 million. Fleur Daniel tried to take it to the High Court. So when you go to the High Court, you first have to apply for leave to appeal. So it's like a preliminary step. You get a leave to appeal, and if you win that leave to appeal, then your matter is then heard before the High Court judges. They didn't win their application, so the High Court didn't hear the matter. So the appeal court decision prevailed, and the principal was then free to deal with the proceeds of the security as it wished. Yep, so pretty much they call on the bond, so they were legitimately able to do so, and there was no longer an injunction to hold that money, so they could do whatever they want with it. Then Fleur Daniel would then, outside the injunction process, would have to launch a separate proceedings against the principal to allege wrongful claim, breaches of contract. It was a massive case. This is just the injunction process. So, yep. Bet your bottom dollar they would have made that $45 million disappear pretty quickly. So that, yeah. So, yeah, I always get lots of interesting questions. People are appalled by this idea of a performance guarantee or a bank guarantee, but you know it's out there and it exists. There are instances where parties get themselves into such difficult positions where a call is in fact made. Yes? They don't. They can't. So if a company is wound up, then the creditors who come in play basically would have to find ways to retrieve the assets of the company and pay off their creditors. So, yeah, it's gone pretty much. Yep. Any other questions before we move to the next topic? So, so contract documents. So a construction contract, you generally have various sections that are put together. The instrument of agreement, which is basically, the first couple of pages where parties actually sign the contract, and just like a bit of the formal element of the contract. Then you've got the general conditions of contract. When I talked about the AS standard form contracts, that generally covers the general conditions of contract. Special conditions, so basically parties agreeing to any special conditions that apply to the contract or amending the general conditions via special conditions. Then you've got schedules and annexures. What do you think would generally constitute schedules and annexures of a contract? Yeah.
Timetables.
Timetable. Yeah. Okay, that's one. The program, potentially. What else? Yeah. Yes. PC sums. One very. Sorry? The pricing schedule, yes. What else would you need in a contract? Scope. That's right. Scope of works, what you're meant to be delivering, and your specifications. That's a major part of the contract. That's what basically will determine whether you have an entitlement for a variation or any other claims under the contract. So if there's any movement from that scope is when you start making claims. So the principal supplied documents could consist of, for example, the preliminary design. So when would they give you a prelim design? Under what sort of contract? A construct only or a design and construct? DNC. Why is that? What would you expect in a construct only contract? Yeah, a finalized IFC design, wouldn't you? Issued for construction. So under a DNC, you'll probably just get a preliminary design. You might have the principal's project requirements. You might get some specifications, maybe a geotech report. And then there's also documents that the contractor supplies, and those are things like the schedule of rates, the bills of quantities, methodologies, and assumptions and exclusions. So what are assumptions and exclusions? What is, yes? Yep. Yep. Yes, definitely. Those are the sort of assumptions that the contractor has made on documents provided to it by the principal, right? And what do you mean by exclusions? What do we mean by exclusions? Yeah, so they've made certain exclusions. Well, what is, yes?
They might provide a non-conforming product, non-conforming product.
Yeah, okay, non-conforming product. So let's, but what does it all mean? What's the significance of assumptions and exclusions? Yes?
So the exclusions are things that they're, I guess assumptions are like assumption in the project, exclusions are services or stuff that's done by other consultants.
Yeah, okay, so stuff, but what's the significance of these assumptions and exclusions?
Used in terms of within condition clause, variation, possibilities of variations.
Possibility to variations. Okay, we're getting warmer. That's it. What they've allowed for in their price. Basically, they say to carry out this scope of works, we've agreed to $10 million, but our $10 million is based on these assumptions and exclusions. So we've assumed this, we've excluded this. Our price does not cover these exclusions, right? So, and then that leads you to the contractor to then get to the point of saying, oh, here we go. We've made these assumptions. We've got these exclusions. These then will entitle us to variations. Okay, so it's basically setting yourself up to claim more money under the contract. Okay, we got that. So they're pretty important, those assumptions and exclusions, right?
So the exclusion is like specifically excluded from the scope of work.
Yep, you say, let's just say the scope says you need to build a 10-story apartment block, and as part of that, you need to get permits number 1, 2, 3, 4, 5, and you might say in your exclusion, we excluded permit number 3 and 5. If required, then we ask for extra time and money. Okay, so that's an example of the sort of exclusion that you might say, right? So you've only priced in your program and your contract price to obtain permits number 1, 2, and 4, 3, and 5 are not included. Because somehow you've decided then 3 and 5 is just too tricky to get. And if we're required to do that, then it's going to cost you more time and money, principle. And you write that down as an exclusion. Okay?
For that definition, like anything outside of scope would be an exclusion.
Not necessarily. You could exclude things that are already within the scope, and you say, because the scope is ambiguous or it's worded widely, sort of broadly, and you might say, my interpretation is I'm only allowing to do that, and outside of that, it's not my responsibility. I haven't priced for it. If you need me to do that, you need to pay me more. You need to give me more time. That's the sort of stuff that you might have. Sometimes the principals project requirements, they're not specific enough. They're quite broadly worded. And it's deliberately helpful for them to have it broadly worded, because then they'll say, oh, it captures everything, right? The world and more. And you as a contractor will go, hang on a minute, it doesn't quite, your 10 million doesn't quite buy you anything that you want. So I'm going to try and limit that. Okay, it's only going to get you this, right? So then you have your assumptions and exclusions. So it's the contractor's way of clarifying the scope and putting limits on what they are selling for that $10 million. Okay. Has anyone ever seen a construction contract? Has anyone participated in the writing of a scope document? Yep. How many pages? So, phase them. And why do you do that? Yep. Yep. So you have some sort of method to control the scope. Yep. Okay. And why is that? Why would you want to control it? Yep. Okay. So you're coming from a consultant's perspective. But has anyone worked in a sort of a DNC contract, a DNC project?
I was working as an architect and we did a specs for the tender.
Yep. Yep. Okay.
It's like 600 pages of document.
Yep.
And it was not pretty.
No,
Okay.
it's not.
It's like literally every single finishing, fixture,
Yep.
up to the brand of it.
Yep.
Everything was listed.
Yep. So that's a fabulous piece of example over there. 600 pages. It's quite a lot of stuff that goes into it, and sometimes some of that is not necessarily relevant. Some of it can be inconsistent, incomplete, inaccurate when you're dealing with a document that size. So yeah, it's what do we do when we have those sort of issues? What happens if there's a discrepancy between the various documents that form a construction contract? So lawyers have thought about this and they say, let's have a clause in there which talks about an order of precedence, which will usually resolve any incidents of discrepancy. So some contracts are quite prescriptive. They will say that in the event of inconsistency or errors or inadequacies, this order of precedence will apply. So the scope document is pretty much the gold standard, and then you might have specifications, and then the general conditions, and then the special conditions. So there's a way of sort of trying resolving these sort of disputes. An example is like that. It's just a standard example. The contract comprises of the following documents. So it identifies the documents to which the following order of precedence applies to the interpretation of any discrepancies. So you've got the formal instruments of agreement, then you've got the general conditions, and then the schedules. So obviously the one in A is the most important document. So if there's any inconsistency between A and D, which one will prevail? Which one is more correct? A, that's right. So if there's any inconsistency between D and E, which one will prevail? D, yes. So you sort of get the idea, right? But only if there's an inconsistency. So both documents have to deal with the same issue, but they deal with it differently. So the one in the higher order of precedence will be the correct version. So what if a contract is silent? Then the superintendent comes into play. They usually use their discretion to make a direction about which document you should follow. And then they generally have a determination on if there's a cost implication associated with that direction. So there'll be all sorts of contractual terms and conditions that you'll have to comply with. Any question on contract documents? Okay, so we move on to construction site. So there's a lot, we talked about the concepts of superintendent, what else did we talk about? Security, and then we talked about the contract documents. But all the action occurs outside of here, right? Where does it occur? On site. So what happens on site? What sort of obstacles you see on site? Coordination of trades on site, access to site, safety on site, what exists beneath the site. Very important if you're starting to dig holes and tunnels. So the construction site itself, it presents one of the biggest areas of risk allocation under a construction contract. So we talked about risk allocation last week, and it's all about the construction site, right? So there's the money element, the time element, the scope element, but then when you get to site, there's a whole bunch of stuff that you need to think about. So the site is usually occupied by the contractor, goes without saying, but generally, there's clauses in the contract which says that, you need to give access to the principal, its agents, subcontractors, consultants, QSs, financiers, blah, blah, blah. And normally you'll have to provide reasonable notice. So generally the main contractor will have control over the site. Has anyone been to a construction site? Yep. And what did you have to do? Could you just saunter in?
Wear a hard hat.
You wear a hard hat. Steel cap boots. Induction. Who said what? Security glasses, right? Yep. So you've got your PPE, right? The fancy personal protective equipment, your hat, your high-vis vest, either yellow or orange, boots, long-sleeve shirts, pants, gloves, and your protective eyewear. But outside of looking really fancy, this induction, what does that mean? What does that talk about? It's a controlled site, isn't it? It's controlled access. You can't just walk in. You need to seek permission. Someone's got to walk around with you. Why do you think that's the case? Sorry? It's a safety issue, right? You can't just have people walking in and out because there's heavy machinery going. It's a high-risk area, right? So you always generally have to have prior permission before you walk into a site. So there are legislation that covers these sort of responsibilities that apply to a contractor. So they're generally called a principal contractor, and there's regulations and legislation that apply to that deal with occupational health and safety issues, industrial relation, protection of property and work, and there's also things like interface between trades and utilities. That's a big thing, and site occupiers. So the contractor also has responsibility for what goes on the construction site and what basically happens when it affects people, so just general public, and the properties that are next to it. So if you're out in the middle of nowhere, people and adjoining properties is not so much of an issue, but if you're working in a brownfield or in a CBD environment, it becomes a huge issue, right? So you've got, while you're in possession of the site, you're responsible for whatever goes on in it, regardless of who is working on the site, subcontractor. So you have a responsibility by law that extends to everything that happens on the site. The contractor generally has responsibility for ongoing conditions on the construction site, For example, site conditions such as soil type, land subject to flooding, nuisance, contamination, and the demolition of existing building. So all of these activities will present risks in their own right? So, and the construction contract will deal with those. So the basic proposition is that a principal will know its land better than the contractor. So you'd expect that any difficulties and risks relating to the site should be borne by the principal. And these sort of issues are generally called latent conditions. They're not obvious or patent, or they're readily visible. Can you think of what might constitute a latent condition? Yes?
The contractor's drilling and encounters rock or an unknown moving ground.
Yep, so underground. It's the first important thing. Generally, you find latent conditions underground. So rock. What else could you find underground? And you could not have prepared for it. Valuable items. Minerals. What else? Fossil. Oil. We haven't quite hit an oil well yet in Melbourne CBD.
Dangerous or contaminated material.
Contamination, yes. But think about this. Would you be conducting a geotech report and sending out bores, right? Wouldn't they give you a sort of indication of what sort of contamination is present on site?
If that's found on the site, then yes.
So what would be latent? Sorry? Depends on how many bores you put down. Sorry? Yep. 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 The soil conditions, yep. So on a large project, you can only put in however many bores you have. You extrapolate and you sort of guess that this would be the level of this sort of contamination exists, and you make a guess as to the sort of quantity or level of contamination, but then the true extent of which you may not necessarily know, right? So you might want to protect yourself against those sort of issues. What are the latent conditions that you might find in the city?
Nearby structures.
Sorry?
Foundation of the nearby structure.
Yes, foundation of the nearby structure. Yep, that's it. Yes, been there. Hey? Underground services, massive issue. Boundary alignments, yes, you want to get that right and not encroach upon neighbouring boundaries. Yep, so you've got to do the correct survey and get your certificate of title right. So yes, all of that. What else? Asbestos. Last week I mentioned something. Do you remember what it was? In the Westgate Tunnel project? Contaminated soil, PFAS. This element, does anyone know what PFAS is? PFAS?
Did they use this as the code for the gas works? It's been used.
Sorry?
Is the code for the gas works? It's been used.
It's fire retardant. It's basically the chemical used in fire retardants. It's, when you have fire and you that foam, it's one of the elements that is contained in that. It's pretty full on for human beings. You get exposed to it, you're pretty much guaranteed to get cancer. So that's a pretty big issue. So there's just quite a lot of stuff that could go underground. You can only do however much geotech reports, but at some point, you can only make an educated guess. You'll never know truly the extent of latent conditions. You might hit a burial ground. You might find artifacts. I remember once we were going to do a development in the city somewhere in Clarendon Street, and the contract was, they knew that there were underground storage tanks because it was previously a petrol station. They thought they had maybe 7 underground storage tanks, and when they went to dig up the soil, they found 27, which is huge. They priced 7, and then they had to deal with an extra 20, and as a result of that, that much more contaminated soil also. What else can you find? In London, unexploded ordnance is a big issue, and so it is in France, so these places that were bombed in the Second World War. All the bombs basically, they sink to the ground, and then you go and dig it up, and you have to call in very highly qualified experts that cost a lot of thousands of pounds to come and secure the site, secure the unexploded ordnance, and remove it. So that's a big issue in some countries. Landmines, sea mines, if you're doing exploratory work, that's another issue also. What else can you think of? When we're tunneling, what could you possibly find?
Like metro line, utilities,
Yeah.
gas pipes.
Utilities, gas pipes. The soil conditions may vary. So over the course of several kilometers, you might think you've got clay here, then you might hit rock. So rock is another issue that you might find. What else? When you hit these sort of conditions, what basically happens, you have to spend more money and more time dealing with these stuff, right? So where do you go to deal? Yeah. Variation. So do you think the contract will have to say, if you hit these sort of things, you're entitled to a variation or a extension of time? Do you think it has to say it in the contract? Yes.
The risk of latent conditions like for contractor protection.
But-
If they've got the site condition information up front.
Yep, so there are instances where the contract says latent conditions lie with the principal because the principal knows it, but sometimes it's a negotiated situation. The contractor will take the risk on some of the latent conditions, and outside of that, it goes back to the principal. Okay, so often it's a shared risk profile. So there are all significant risks in a construction project. So each contract defines latent conditions in its own special way. In the Australian Standard Form 4000, if you look at clause 25.1, it basically says conditions which differ materially from conditions which a contractor should reasonably have anticipated, or which should have been anticipated by a competent contractor. So, yep. So there is generally wording around that you should have done all the necessary checks, research, and if you've done that and you still couldn't have anticipated these latent conditions, then yep, it's a latent condition and you're entitled to more time and potentially money to deal with it.
Can we use the assumption and exclusions instead of latent conditions?
You could, but if you're assuming that, then you've already probably thought that it's a risk, right? So you could. It's another way of sort of excluding latent conditions, but the general conditions already deal with it. So let's just say you deal with it in your assumptions and exclusions, and there's a clause in the general conditions of contract. If there's some inconsistency between those positions, what would you want it to be? You'd have to decide which document is more correct, right? So ideally, you only deal with a subject matter once in a contract, right? So there's no argument of inconsistency. So if you've already dealt with it in your assumptions and exclusion, and there's also a clause in the contract, and your lawyers have dealt with it, you want to make sure that one of it, when you have the order of precedence, that the correct one is higher, okay? So, and if they're not matched, okay, the assumptions and exclusions. So the test for whether a condition is latent is subjective and will differ from project to project. What would a competent contractor have anticipated will depend on how much information is made available during tender, what sort of information is available publicly, how much investigative work the contractor was able to undertake during the tender stage. So if it's a short tender stage, they can't really do much. And if the geotech reports were commissioned by the principal, can the contractor rely on those? So the principal will usually try to transfer some of the risk of latent conditions to the contractor, and they normally do that by expanding the definition of site conditions. They will disclaim responsibility for reliance on documents that they've provided to the contractor, and they will often insist on warranties from the contractor that it has made all the necessary investigations. So these are all sort of contractual provisions, and sort of lawyers get involved in doing all of that. So this is a short case study, and it was the Tullamarine case where Morris Cruston International and the Commonwealth. So the principal is the Commonwealth. In this case, they supplied ground condition report. The actual conditions are obviously different to those in the report in relation to the existence of cobbles. The principal had disclaimed accuracy of the ground condition report, so that obviously there was a condition in the contract which says don't rely on this, it's not accurate. So basically that would mean the contractor had to rely on those reports at its own risk, so it wears the risk of the accuracy of those reports, and basically had to do its own site and subsoil investigations. Despite these provisions, the High Court found in favour of the contractor on the basis that the report contained basic site information which the contractor could rely upon. Right? So I won't try and bore you with the full details of the case, but basically there are instances where courts, if the facts support their decision, that they will find on behalf of the contractor. So all's not at loss, right? It's not always the contractor that has to wear these risks. So if you find a latent condition, generally the Australian Standard Form says it's a deemed variation, but you'll have to provide the necessary notice provisions, and then it's generally up to the superintendent to make a determination on whether it is in fact a latent condition that qualifies for extra time and money. So just circling back to a superintendent, how do they handle the number of activities and competing issues on site? There's constant communication, there's site meetings, there's stakeholder meetings, and you have comprehensive record keeping. So there's a lot of documentation that goes into play. Then we come to subcontracts. What do you understand as subcontracts? Who are subcontractors? Who are they subcontractors to? Who hires them? The main contractor. Yep. So you hire downstream subcontractors to do what? The actual work? Yep. Yes. Sometimes you self-perform, but sometimes yes. No. This contractor is meant to run the whole project. So if the principal hires a subcontractor, it's probably for a different project. So you hire the main contractor, you give them the responsibility to carry out the project. Main contractor goes out to market, hires subcontractors. So they're basically trades. So if you're building an apartment contract, you might go and get a subcontractor to build, to do tiling work, pipe work, painting, roofing, temporary works, carpentry, all that sort of stuff, right? So you hire different trades to come in and do the works. You might go out to suppliers, separate suppliers, to get concrete, cement, that sort of stuff, right? So you basically go out and get suppliers and subcontractors to carry out the works, and they generally have specialist expertise. So generally the contractor is free to choose its own subcontractor, except where they're quite significant pieces of work, then sometimes the principal or the superintendent might have a say in the choice of the subcontractor, so you might just need to clear it with them first. So whether the subcontractor is chosen by the contractor or nominated by the superintendent, the main contractor still has responsibility for the works of the subcontractor, right? So what that basically means, if the subcontractor does something wrong and the project goes wrong, the principal does not have to sue the subcontractor, it just sues the main contractor, because the main contractor is still responsible for that work.
Sorry, when it's a nominated subcontractor, doesn't the principal have some risk?
Generally not. You hand it over. They just nominate, and pretty much the contract is between the main contractor and the subcontractor. So there's no privity of contract between the principal and the nominated subcontractor. So I think that's what you're probably talking about, but it's always with the main contractor. The contract is between the main contractor and the subcontractor.
Even if the nominated subcontractor changes his fees, because normally when that happens, when the tender goes out,
Yep.
the contractor's tender
Yep.
included in the contracts.
Yes.
But if you have to use them and they turn around and change their price,
Yep.
is it the
You'd have to be very clear about ensuring that your variation entitlements allow you to deal with such rise and fall. Yep. So you'd want to obviously stick some fat in the subcontractor's price, right? So you're covered for any increases. Yep. So the key requirements of most subcontractors are they sit back to back with the main contract, so they sort of do a bit of a match up. Sometimes there are provisions in the contract which allow the principal the right to remove subcontractors if it no longer wants on the job. And there are also contracts which will require contractors to obtain warranties as to quality of works from subcontractors directly in favour of the principal. Yep.
There's a security bond between the subcontractor.
Yes, and the main contractor. That's how the main contractor covers himself also. So they're not meat in the sandwich. So novation, so this generally happens, for example, when the principal has got a design consultants on board, and then they want to pass on that design consultant to the main contractor so that they can carry this continuity. So they would have started the contract between principal and the design consultant, and then they novate that contract across to the main contractor. So it's a transaction by which, with the consent of all parties involved, a new contract is substituted for one that has already been made. So I've just said that. So defective works. So this is pretty much the last two items that we're coming to: defective works and defects liability period. So what defines the quality or standards of the works? So what you're meant to deliver, the standards and the quality, they're generally set out in the scope of works and the principal's project requirements. That should be pretty prescriptive of what's expected in the finished product. And generally you will have to provide a warranty that will say that you've basically achieved the requirement or the fitness for purpose of that product. So there are standards and protocols that apply to the type of work being carried out. For example, you've got Australian standards, and sometimes there are industry-specific requirements and legislation. Some very, very basic example that you have in terms of legislation: when you build a publicly accessible a building or structure, for example, like hospitals, schools, museums, train stations, there will be this requirement that says DDA compliant. What does that mean? Access must be DDA compliant. What do you think that means? Disability, that's right. So what would that basically stipulate, the Act?
Access should be
There should be ramps
ramps, yes.
instead of steps.
Yeah.
There should perhaps be railings.
And visual
so the scope might say you have to be DDA compliant, and as builders you should understand what that means. You should understand what the legislation says about that, what the code says about that, what the regulation says about that. So they may not necessarily identify each of this in detail, but they may just say it has to be compliant, and then you have to go out and make sure that it is compliant. Why would you not specify all those regulations? Why? Why do you think you might just keep it broad and say it has to just comply? Yep.
They might change over time.
That's right. They keep changing, right? They keep getting tweaked. So the numbers change, the versions change. So just say, at that point in time, in April 2019, whenever you get around to building it, you just make sure that it's compliant at whatever it is at that point in time, right? So a defect basically notes that the workmanship, the design or the material does not meet the purpose for which it was intended, right? So it's defective work. It's not good. Try again. So what would the principal do if the contractor fails to perform the works? They may give them a direction to rectify defective works. And if the contractor fails to rectify, they may either have the work carried out by third party, or they may call it a breach. And they may even terminate the contract because there's a breach. So if it's serious enough, it's a sort of nuclear option will be going down. So you've carried out the works, you've sort of got to certificate of practical completion, and the defects liability period is triggered. Generally, it's 12 to 24 months. So you get to the defects liability period. What happens then? What do you think happens at the... Are you still on site during the defects liability period? No? What happens to you? You've demobilized? Gotten the hell out of there? Handed over the works? Given them the keys, locks, everything? What happens during the defects liability period? You don't control the site anymore, but what are your obligations?
Contractor has to come again and repair the defects.
That's right. And do you get paid to repair those defects? No, that's right. So what's the motivation for you to come and do it? The security, that's right. You still have that 50% of your security that's on hold. So there are various sort of obligations that you need to carry out the rectification works at a time in a manner that causes as little inconvenience to the occupants or the users of the works. They may, if you don't do it, they can have someone else carry it out, and the cost of which will be a debt payable by the contractor to the principal. And that pretty much sort of brings you to the life, sort of stages of the construction contract. Do you guys have any questions? No? Okay, all good.
No questions, or you want of course the presentation? Took a good words.
Yeah, I think they've exhausted themselves.
Thank you again,
You're welcome.
and we shall see you next week.
Excellent.
Okay. Are you okay?
4 quarters.
Four quarters, yeah. All right, let's take about 5 minutes or so. Then I'm going to put on that Four Corners show. We can have a look at that and a discussion about it. Okay. Defects. It's worked perfect.
there's the exclusions and,
Yeah.
and that sort of stuff. In your tender, putting it into a normal contract, there's not really space to allow those to become part of the contract. How do you make them part of the contract?
By basically insisting. That's about all you can do. I mean, you know what it's like. You tender, give us the tender documents.
Yeah.
Give us the tender documents. You have a look at them and you go, righto, okay, well, I'm going to rely on this as best I can. Yeah, put in my tender. And you say, yeah, but if this, and this happens, then that's not included. That's excluded from the price.
But that's a super environment to do tender analysis. If anyone had that, I'd just be non-conforming tender before you sign.
Yeah, I know. It makes it really hard.
Yeah, because when the documents aren't good enough, it's just trying to think.
And that's why the construction lawyers have a ball.
Yeah.
You know, if you sit down and you're reasonable about things, but who's reasonable?
Yeah. I was always looking at how can I do that, because once you start understanding the risks and stuff, that you're happy with it. You're going to look at how can you try and mitigate some of that.
Next week she'll talk about the types of contracts in more depth from memory, and you can be, you know, we share things and we do this and we do that.
Yeah. Because it was one of the things I asked you earlier, just now the red book one, the domestic architects one, I found a lot of architects just don't know how to administer it. Like they know the basics of it, but some of the things like, variations, what percentage can be put on variations, where they're, on that one I think it's got a variation for positive variations and another one for negative variations. So you actually have two different amounts.
And you know, it's a lot easier to do in a residential sense. I know when we did our renovation, the guys were contracting, okay, that's fine, good idea, let's put it down, let's do this, and this. And I put in it, no variations, unless it's agreed in writing, because if it's not, you're not getting paid for it. And the deal was, when they came to have a look at it, I said, don't ask me and say, oh, we've only allowed for one PowerPoint electrical bill, we've only allowed for so many light fittings in the rooms. You give me how plugs everywhere. You have to increase your quote now for me to say, okay, let's do it. That's fine. But if I walk into the kitchen and there's only one light, there's only one plate, and you know that we're going to have a toaster, a mix master, a coffee machine, I want them everywhere. So allow for it. Yeah. And the guy did. Yeah. Which was really good, because at the end of it all, there was no argument. Yeah. And it was, shit, how easy was this? But it was. It was a matter of, don't ask for anything. Yeah. If I ask for something, then we agree to write it. Yeah. Or we take it from there. Yeah. And that's
generally how they run anyway.
Yeah. But in the big construction, it's just...
Everything's documented, so
correct.
Like, you get away with a little bit maybe if you're just doing normal residential, or if you're getting someone into, some people used to do a bit of design and type stuff. So that got kicked in the head. So I think Master Builders even put through all the design and construction contracts at one stage. But
she'll know more of the answer if you ask her.
Yeah, because it's
really
just
will.
how to do it. Because I had to get one before. I mean, one of the general Master Builders on-site issues there was to do it, just to be able to get, so the client could have a superintendent, because their contracts didn't allow for that. So they just wrote up something that could go into it. But it's whether there's something you can do as a generic thing that allows that to go in the architect's contract.
The thing that I've found is that when membership organisations prepare documentation, so this is pro forma, she's got huge holes in it. It's very, very basic. Yeah. Give it to a lawyer who starts adding and adding.
If they can. I used to use the Master Builders Act because I think that stood up. Nobody's actually beaten the Master Builders Act.
Yeah, it wasn't too bad.
Yeah. But it's the architect's one, so you could even see in writing how
I've sent you the email.
Section
My name
20.
is Yuki.
Yeah, section 27. No,
Section-
the other one. Yeah,
not
yeah.
that one.
Yeah.
It's about
And I responded to you.
yeah.
Yeah.
The question is about is about the parliamentary system and the legal system. I can define them. You told me if I have another question. I mean the further explain it. I want to do this.
Okay.
Yes.
The Parliament makes laws.
Yeah.
They don't interpret them. They make the laws. If there's a dispute about the laws, it goes to the court because there's usually two people arguing about what's right and what's not. It's the same with, let's put criminal law on one side. Let's forget that.
Yeah.
But in the common law system and in the civil law, between parties, if an act says you can or can't do this, the judicial system will interpret what they believe the Parliament was planning for the law to do. Okay, so you have the Parliament, they make these laws, and then the courts will interpret those laws.
So you mean the legal system is like the High Court? Is the they do the judicial
the common law
thing?
The parliamentaries, they write the laws,
Yes.
and then the judiciary interprets the
Means
law,
explain the
explains
law.
it, and then says, Yuki, you're right,
Yeah.
and the other person's wrong.
Yes.
Okay, so we're going to interpret it that way. This is what they mean. And then what you do is they will do it, and I've done this, I've had arguments, join in, I've had arguments with people over the interpretation of a section of an act. First thing I do is I go back to where it was first drafted, to the bill, and then what happens is that the minister who's proposing this legislation stands up in Parliament and reads through what they believe the section is intended to do. The difficulty is sometimes there's nothing about it because people just take it and go, oh, okay, so they read it and this is it. No one said, but hang on a minute. Okay, so then it's left up to the court to decide. Some years ago I was having arguments with different real estate agents about the definition of the word agent in the Sale of Land Act and the service of a cooling off notice, because the Act used to read, it served on the vendor or the vendor's agent. Right. Now, when I went back to the bill and the drafting of it all, there was nothing in there that said who this agent is. Now, what had happened was that cooling off notices where a buyer can walk away from a contract when they buy a property at private sale, a residential property, everybody just took that to mean the real estate agent. Okay, now my interpretation, being a lawyer, was no, they're two different things. An agent has the right to bind their principal, an estate agent doesn't. An estate agent is a servant of the principal. So the service of a notice on that person is not correct. And when you look at a contract, the contract actually specifies service of notices.
But the contract of sale.
The contract of sale has a general condition in it about who you serve a notice on and where it is. So should you look at that? Right. Now, huge argument. Now, it turned out that as a result of a particular case, the court said, no, the agent isn't the estate agent. So what happened is the state government had to change that section of the Act. They changed the section of the Act to include an estate agent.
Now it's less ambiguous.
Now they say it's the vendor's agent, or the vendor's estate agent.
Yep.
So they changed the cooling off under section 31. Okay. So that's what happens. The Parliament drafts it, it comes into law. People interpret it until someone says, stop. That's not the meaning of it. And they go to court. And a judge sits there and listens and goes, I think this is it. And they come up with a decision. Now, in that instance, with the cooling off, lots of people said, Judge got it wrong. But if you read the case, which is called Tan versus Russell, work out the logic of how the judge came to the decision. And I look at it and go, he's right. He's right. Now, people that kept saying, he's wrong. No, he's right. Read it logically. Okay, that's what I mean by that. All right?
Okay, so there are two totally different systems. So this is
okay. Judge makes it. Okay.
Yeah.
Judge made the law.
so the judge to make the law according to the common law or common
according to
civil
the common law, but they will also
based on the
interpret.
civil law.
But they will also interpret what they thought that law meant. Sorry, what it meant. Okay.
Okay, so that is what they thought it means. That is the common law.
Yeah. Draft something up and let me have it, and I'll tell you if you're on the right track.
Another question.
Okay.
Yeah, we both have this question is what is the law of governance? So it's a type of law.
No. Law of governance. It's the system. It's the system. The law of governance is the hierarchy of who's got control. Okay. And it's that separation of power. So you have the Queen as the head of Australia, her representative Governor General. Then you have the Parliament, and you have within the Parliament the executive, the ministry, the cabinet.
It's like a framework.
And it's this.
Yeah, I see. What do you mean, like the what is it, the triangle?
Yeah. All right.
Yeah.
Put something in. Show it to me.
Okay.
All right.
And do you have the words required?
No.
Like the 2000,
No.
3000?
No.
But
Don't give me one page.
yeah, or 2 page.
Or 2 pages.
Okay,
All right.
got it.
Okay.
Thank
All
you
right.
so much.
Pleasure.
I saw this last week.
You can go. We're going to watch it. There was actually when I first had a look
It's
at this.
interesting.
It's very interesting. There was a shortened version of it, 7 minutes. And it's just
Is it part 2 tonight? I think it's a part 2 tonight, potentially. I think so. What's your name? Tom.
Do you work in that?
Yeah, I do.
Because on last week when I was on yeah, hang on, there we go. Somebody knows more than
Yeah, well, I used to work in big roads, and now the major projects that we've become down Florida.
Yeah.
Just now major road projects Victoria. So I'm working on more down at Korea.
Yeah.
So yeah, it's a very interesting project because there's a lot of land acquisition there. So I've actually been involved in land acquisition. Very fascinating.
Yeah, it is, isn't it? It's going to get money away. Negotiate as hard as you can.
Now it's in negotiations.
And then get out.
Yeah.
Because the people who are left, 1 or 2 streets back.
You gave that Camberwell example with the car park.
Yeah. You know, it's just, I don't get it. Take the money.
There's rules out.
Unfortunately for them, though, at the moment, they believe their problems are devalued. And that's their issue. So what
And
they
there's
need...
also emotion.
Oh, yeah.
It's all emotion as well, yeah.
My mother died, my oldest brother couldn't walk back inside the house and go, she's dead. It's fucking bricks in the water. It's bricks in the water. That's right. And my other brother and I just kept saying, it's a house. What is bricks in the water? Yeah, that's it. So, yeah.
So yeah, so I'm going to get a day off just to study the government every day, just to come to uni and study. So it's cool. It's a good setup.
It is a good setup, isn't it?
Thanks for everything.
Pleasure. As long as you're enjoying this,
Yeah,
this is
love
good. Good. Okay. We've lost a few. That's okay. Top score last week. Anyone see this? There was a shortened version of this when I got onto internet last week after it. Actually sat and watched it. I'm very lucky when my wife's away, which is most weeks. I get to watch on TV what I want to watch. Although there's 2 of us. We've got 3 TVs in the joint. I mean, which is ridiculous, but we have. The most important one is in my office, so I can watch sport when I'm working if it's on. But it gave me the opportunity to watch this, and as I watched it, I thought, next week after the lecture, just perfect. Some of what was discussed tonight was in it, and it's about the construction of high-rise apartments and what's happened to it. There's a comment in this from a particular chap said, basically it all started to unravel in terms of the standards and the quality when the local councils, and you'll hear him say it, so this goes for about 40 minutes, okay? When the local councils divested themselves of responsibility for signing off on the work and putting it into the hands of private enterprise, because most of the people that do it are hired by the contractor, by the people that do the construction, and it's in their interest for it all to be signed off. Ironically, on the Friday before this, sitting having coffee with my 95-year-old father-in-law who used to do a bit of construction and development, he and I got talking about it before this happened, and his comment to me was, and I'll clean it up, Phil, it all went belly up the minute the councils went, we're not doing this anymore. And he said the standards dropped dramatically. And that's why we've got the quality of work and the quality of build that we have today. Which is a real shame, because the one thing that we could have relied on in the past was knowing that our construction industry was pretty good, particularly in residential. So what I'm going to do, and if you all get sick of this, let me know. And, you know, we might stop it somewhere and say, let's watch the rest of it or something a bit later on.
Good evening. We begin our bulletin with breaking news.
Australia's apartment building industry is in crisis.
Emergency operations underway at Sydney Olympic Park.
For decades, it's been harbouring a dirty secret
Due to fears that a 30-storey apartment building,
a litany of construction defects.
Tonight, a 30-storey building evacuated
Over fears an apartment block
could collapse.
A tower of uncertainty, cracks in the foundations, the facade crumbling, and hundreds of residents left out in the cold.
Do you have anything to say about the people still inside when the building's been evacuated?
It's a problem affecting thousands of new apartment owners across the country.
For many people, it's their only asset, and the expectation should be, in Australia, my greatest asset should be safe.
It's not until, as we've seen, people exit their properties, have to be out on the streets basically, does this start to, come to the attention of the government.
I just think that it stems from loose regulation, government regulation. That basically, it's a cowboy industry.
There's clearly a crisis of confidence, and there needs to be a lot of work done to rebuild that confidence broadly across the community.
If I have to pay for the repairs myself, I would have to go bankrupt. There's no way that I could pay for it if it was asked of me to pay my share. I don't have the money, I couldn't get any more money loaned to me. I would be done.
Tonight on Four Corners, we investigate what's gone wrong with the Australian construction industry and how decades of inaction has fostered a crisis that will last for years to come. On Friday, June 14, Rosalind Lean took an early train home from her job in the Sydney CBD after a disturbing call from her son.
I was at work. It was about 4:30, 4:45 in the afternoon. Isaac had the day off work. He rang me and said, "I don't want to alarm you, Mum, but I think something's going on here. There's a lot of workers in the car park basement." This station is
The Leans lived in a 10-storey apartment complex built above the station, Mascot Towers. Days earlier, cracks had been detected in the car park. Engineers were called in, and they discovered the building was moving.
So the initial 000 call came in and it gave information about a potential building or structure collapse from the owners from that building. So we classified that as a building structure rescue or collapse. So our initial response to that was 2 fire trucks and a rescue truck.
I saw a high vis worker guy on the lift, and I just said to him in jest, you know, is the building going to collapse? Just expecting a big no as a reaction. And he turned around calmly and said, well, yeah, there's a good chance there is. And I said, how much? He said, oh, probably around about 60%.
Sirens started to come. Police, fire engine, all these sirens.
The first questions that we asked, is it a collapse, is it a pending collapse, is it a potential collapse? And the information we had that it was only a risk of collapse. So my head goes around, what are the risks, the areas, what resources may I need? I start thinking along those lines as I'm approaching.
I went downstairs, a fireman came up to me and said, if I was you, I'd be packing your bags.
Ready to go? We decided in conjunction, in a collaborative approach with the whole team that was there of engineers, police, ambulance, of the best way forward is now to evacuate, just to stop us, to protect the safety of everybody within that building.
Residents were ordered to gather a few essentials and get out.
The building manager said everyone has to be out by 9 p.m. I think at that time when we found out it was probably 7 o'clock. So we had 2 hours to pack everything and arrange accommodation and get our cars out and all sorts of things. So it was chaos.
The police, they were closing off the street. It was just get out. Basically, get out. And you're in shock. And I think when you get out, you're starting to think, did that really happen?
People were confused, obviously. It was a Friday evening, they'd come home from work, some were coming home from work. So obviously a lot of stuff happening around their place that they need to get information for. And we did our best to try and actually keep, a level of, obviously calm and work through like we would at every incident. Obviously very emotional and confusing time.
The drama at Mascot Towers has become symbolic of the crisis that has engulfed Australia's apartment industry.
Oh, this is a pivotal time. There's certainly a crisis of confidence in the broader community. There's concern amongst industry. There's concern amongst organisations like ours at Engineers Australia. So this is a pivotal time to take action and to fix it.
Mascot Towers has a troubled history. Craig Young was one of the first to buy in. So Craig, which one was yours?
My apartment was the first balcony you'll see just above this podium level here. I first bought into here in 2009. At the time it was one of the few places around here. I think it was only the second apartment block in this area. It was convenient, close to the train station and close to work for me, which is not far away, so it worked out well.
Within a few years, defects started appearing.
At the beginning we had minor defect problems, hot water, small things like that, not major. Later on we had a few other defects that were resolved.
In 2012, the Owners Corporation met to discuss suing the builder.
When the chairman called for a vote on a motion to proceed with legal proceedings, which we had to do, to spend that sort of dollars on the efforts, a representative of the builder and developer was there along with their lawyer, and they stood up. And the representative from the builder said, if you proceed with this, you'll never be able to sell your apartments. And that left everyone sort of wondering whether they should proceed or not, obviously.
What sort of shape was it in when you first bought it?
When I moved in, it was a new building.
Craig Young sold his apartment 5 years ago, well before the current structural cracking emerged. And what do you think about that decision now?
I dodged a bullet, obviously. I feel for the people that are here, and I'd hate to be in that position.
Mascot Towers is 11 years old, so the owners have run out of time to sue the builder if he's found responsible for the cracking. Depending on the state or territory, apartment owners only have between 5 and 10 years to sue for major structural defects. Two months after Mascot Towers was evacuated, the owners are still waiting to find out what happened.
From what we understand so far, it's not really owners' fault. Their building's in the situation it is. It's major cracking. We've got experts all over the place at the moment. So until we get all that back, we really don't know what's happened, where it's happened, and potentially whose fault it is.
I'm embarrassed, frankly, that the industry has allowed a product like Mascot Towers to turn up on the marketplace. But you know,
on Friday, at a New South Wales parliamentary inquiry, the newly installed State Building Commissioner David Chandler made it clear who he thinks is responsible for the problems.
My personal observation of the engineering design is that it's poor. And I've built a lot of buildings. And I have to say, when I walked across that job yesterday, I don't think I've seen many buildings as poorly built as that, okay? There's a builder there that was operating that really shouldn't have been in the space doing it. They didn't have the capability. They certainly didn't know how to read a construction drawing, but perhaps the drawings in the first place were flawed.
Four Corners tried to speak to Mascot Towers developer John Elias. Oh, hello. Mr. Elias? I don't think he wants to talk to us. Lawyers for John Elias said the building was constructed in accordance with all development approvals.
We're just moving from location to location and we don't know when we can move back home.
That must be intensely frustrating.
Yes, it's living uncertain every day. One day we could be notified of moving in. Tomorrow, the next day, we could possibly be notified that we can't go back in for a year, or worse, that the building has to be demolished.
Is this an isolated case, or is it symptomatic of something that's going on?
Look, I think construction defects themselves are symptomatic of the problem across, and this is just one example. You know, you've seen in the press recently, more and more buildings now are coming out and saying, "Hey, we've got problems as well with defects."
Mascot Towers is part of an Australia-wide apartment building boom that has lasted for 20 years. Since the Sydney Olympics in 2000, more than 650,000 apartments have been built across the country.
People are reinventing what the Great Australian Dream means for them, and for a lot of people that's still the suburban block or the freestanding house. But for a lot of other people, that's something different. It's an apartment in the right location with great access to employment, enjoying a vibrancy of lifestyle that you just don't get in the suburbs. The big growth in apartment living has come in recent decades, last 2 or 3 decades in particular. It's been a transformation.
But the boom has come with a hidden cost.
But how common would you say defects are across buildings in Australia?
Very common. It's very common. We've got a real problem here. It's systemic and it's infecting lots of buildings across the landscape in all parts of the country. It's very clear and it's very prominent, and we've got a serious problem here.
What we're seeing is the outcomes from a poorly oversighted industry with lack of competence and in some cases a lack of integrity. Commercial imperatives have really overtaken public interest in terms of decisions that have been made.
Lawyer Bronwyn Weir co-wrote a major report in February 2018 for federal and state governments that identified many of the problems that have since come to light.
I guess the things that we predicted and were worried about have manifested themselves in these, really tragic and awful circumstances for occupiers of those buildings.
The extent of the defects problem was revealed in a landmark study published in June this year. The figures are staggering.
In New South Wales, 97% of the buildings that we looked at had at least one defect in multiple locations. That was followed by Victoria with 74% and Queensland with 71%. There's a chronic problem here. There's multiple parts of the building that are affected by defects. It's not isolated to one type of or one part of the building. It's across multiple areas in relation to how the building has been constructed.
The problems plaguing Australia's apartment buildings start right back at the drawing board.
The process starts not as commonly thought, with it being the tradie turning up to site and doing a bad job, shonky tradie sort of thing. That is a common misunderstanding. In fact, the process of these defects being generated starts right at the beginning with the developer.
Industry troubleshooter Ross Taylor says a common practice by developers is to use big-name architects just at the concept stage to give the project sales appeal.
Developers, when they develop a strategy for selling, they have to get the sales off the plan straight away. Once they've got the pre-sales and the bank then allows the money to flow, they then cut the name architect and then go to an unregistered design, unregistered architect or draftsman, just to map out the basics to go to tender. That's the start of the defects.
In the industry, it's known as the design and construct model, and it's at the core of the defects issue.
The builder, who has no training in design, by the way, now takes responsibility for the design done to date and completing the last half of the detail. Now, he's doing that on a tight budget, and so what frequently happens is he gets the subcontractor to finish the designs the way they see fit. The subcontractor doesn't have time to complete that design, and so he gets his tradies that turn up on the job to finish the design off on the go. That's the design and construct model that's operating in most of these high-rise buildings and is at the heart of the problems that we see today.
The 120-unit Alara complex in the Canberra suburb of Bruce began with excellent credentials.
The developer in this case had hired one of the best names in architecture in Australia. In fact, the architects that had designed Parliament House in Canberra. It doesn't get better than that.
The award-winning architects were replaced before construction started. The problems at Alara began within a couple of years of its completion in 2007.
The initial thing was, I guess my daughter who was living here was saying, "Oh, Dad, we've got some leaks in the balcony, or the car park's full of water." That was the initial thing, so I then made inquiries to the strata manager about what was happening, and then the full detail was revealed about the number of issues that we had here.
We've then got occupancy certificates and people start moving in. People have lived here for years now, and it's, I don't want to say it's falling apart because it's not, but it's got a lot of issues.
And how much worse does it make it, given that it was, your first home?
It's shattering. Like, this is what I say for all young people are encouraged, save up and buy your first home, because then you're set for life, everything's good at that point, but it's not. Not when you move into this.
So Ross, this is the place?
Yes, typical type of design, 3 stories high, concrete frame structure.
The owners called in defects expert Ross Taylor.
The most apparent waterproofing issues of water through balconies and into basements and garages. It then had substantial cracking on the facades, render and brickwork of the facades, which is apparent to anybody walking around the place or buying. Then there were fire regulation issues, and there were structural adequacy issues that had to be addressed.
Here is what's called a construction joint or an expansion joint over the top of the garage, which leaks anytime it rains.
After failed attempts to get the builder to fix the defects, the owners took him to court. But the builder placed the company, B&T Constructions, into administration, claiming millions of dollars in debts.
It became clear following the appointment of the liquidator that there was no money for the owners' corporation. In fact, there was no monies for a number of owners' corporations that the builder had been responsible for.
So this was a tactic, was it?
I mean, I can't speak to the mind of the builder, but he had a group of companies. There were intercompany loans between those companies, and certainly I would expect that the intention of having a group of companies was to protect his assets and ensure that it was difficult to get at any monies that were around.
The Alara owners tried to claim against a special insurance fund set up by the ACT government, but the federal court ruled they were outside the 5-year maximum period. The owners are appealing the decision. If they lose, they face a multi-million-dollar defects bill.
It's mostly the stress for me. I'm quite lucky that my apartment itself isn't affected. I'm not like other people who have leaks within their apartment, who have mold growing and things like that. So I'm pretty lucky in that way, but it's the stress of it, knowing that things could go wrong in the federal court and I could be dumped with the cost of my share of repairing this place.
We're now in retirement, we're still paying off a mortgage, and that's our superannuation money just going to pay off a mortgage, which we never intended to do. Instead of our money running out when we're 92, it might run out when we're, I don't know when it'll run out, but certainly it's our superannuation money now that's paying the mortgage off on the unit.
And in terms of the value of the unit, where are you now from what you paid for it initially?
Probably minus 50 or 60,000.
Alara's builder and developer Ivan Bullen has a history with ACT regulators. In 2015, one of his companies was fined $10,000 over defects at a separate development.
Ivan Bullen might have walked away from Alara, but that hasn't stopped him developing new projects. This is one of his company's latest ventures, selling high-end apartments off the plan in central Canberra.
Four Corners approached Bullen Group for an interview, but didn't get a response.
If I have to pay for the repairs myself, I would have to go bankrupt. There's no way that I could pay for it if it was asked of me to pay my share. I don't have the money, I couldn't get any more money loaned to me. I'd be done.
Of all the defect problems, water issues are by far the most common.
They affect people directly, they affect them every day. They cause a significant amount of damage over and above the defect itself, and so they're very expensive defects.
So yeah, this is the apartment. Oh wow, it's been gutted. Just, I'm not sure.
Bronwyn Kosh bought her inner Melbourne apartment as an investment 2 years ago. It's the first time she's been back since rectification work began after serious water damage.
Basically, before this, the apartment was full of mould. So this is the bedroom here, and this was like a walk through and wardrobes on either side. The bathroom, so the mould was basically all through the wardrobes. The mould covered the whole of the roof, down the side of the walls, and spread over to the other side as well. So it was all over the roof as well. And it was black mould as well. So it basically rendered the apartment unlivable.
The problem started weeks after she bought the place, shortly after her first tenants moved in.
And every time they had a shower, the bathroom would flood because the floor wasn't falling the right way. We've had irrigation out the front that flooded my whole courtyard. Then the last flood, which is what caused kind of like a bomb, was the tenants come home and found the carpet completely saturated. It looked as if water had been running down the walls, or it came from somewhere around here. So, yeah, it was quite devastating.
Pretty much got to start from scratch.
Pretty much, as you can see, yeah.
The builder accused her tenants of sabotaging the apartment so they could break the lease.
That's what got me angry. Yeah, it was, how dare you blame my tenant when clearly it's your fault. Yeah, it's your shonky workmanship.
Bronwyn Koch was forced to sue her builder because he didn't have insurance covering her for defects or unfinished work. In Australia, builders don't need the insurance if the building is over 3 stories high.
So, of course, this apartment is more than 3 stories high. My builder doesn't have builder's warranty insurance. So I've got nothing to come back on, except the builder himself.
How surprised were you to learn that?
Horrified. Absolutely horrified, because it's not known.
If people are not prepared for that kind of financial burden, they can find it really devastating. And I see it with almost all of my clients coming to me and asking, well, what do we do now? And unfortunately, they all have to spend more money on more expert reports, more legal fees, before they can even get the builder in a room to start talking about what they might cover. And generally, they're always somewhat out of pocket, even if they do recover part of it from the builder.
Yeah, I've just got no words. Like, I never expected this at all. And I never expected to not have support or backup from, you know, the government departments and things like that. And, you know, where builders or whoever can just wipe their hands and go, not my problem, and I'm left standing with, you know, something that completely wasn't my fault.
Listen to it, listen to it! Listen to it!
The other major defect issue is fire protection. In June 2017, the world woke up to the dangers of inadequate fire prevention in high-rise towers. The Grenfell disaster in London killed 72 people. The fire spread due to flammable cladding. Flammable cladding on Australian buildings is now in the spotlight. But other common fire safety defects largely remain hidden.
I have never seen a building that isn't defective in some way. Yeah, and I mean, I know it's my job, but even just walking around in public, I notice these things. I've never seen a building that isn't defective.
Forensic engineer Jonathan Dooler sees firsthand the consequences of cost-cutting and poor design.
So this building, the apartment doors aren't actually fire doors. They're just solid core doors, and they did that to save on cost. Fire doors are quite expensive, at about $1.5 grand to install. These ones are a couple $100.
So what does that mean for the fire safety of the doors?
It means that you're only going to get a maximum rating of about half an hour that the door can resist fire, but that's not guaranteed.
He's taking us through a Melbourne apartment block with serious problems, including fire stairs that, in an emergency, could put lives at risk.
So in a fire, there'll be a lot of smoke in the hallways, people won't be able to see, emergency lights will come on, but that won't make a difference. Then they'll get to the doors, then they'll come into the stair, and they might be faced with 750 people trying to get out at the same time. As you can see, there's no space to fit that amount of people.
What's the primary motivation for the builder of doing what's happened here?
Primary motivation is definitely to get more floor space that is sellable. And in apartment buildings, that's worth a lot of money.
So given all the regulations that are in place, how does a system like this get signed off in a building like this?
Well, it started with the privatisation of the building surveying industry.
One of the biggest changes to the building industry happened 25 years ago with the shift to private certification. State governments started allowing building work to be signed off by private contractors to speed up the approval process.
The certifier in this current system is contractually obligated to the developer. The developer hires them. So in a lot of ways they're representing the developer, not the future owner. And the certifier system then has become virtually, it's a placebo system. It's one that you put in place when you feel you have to have one, but is of no actual effect.
How big an issue, in your view, has this been in creating the current situation?
Well, depends who you ask. Some stakeholders say this is the very reason for all of this. The certifiers themselves, of course, deny that.
There are bad apples in every process, in every discipline. So yes, of course, building certifiers have a case to answer in relation to the quality of construction in New South Wales and Australia today. In terms of the proportion of responsibility or proportion of blame that the certifiers are receiving is very damaging to our brand, very damaging to our discipline, and blatantly, completely incorrect and inappropriate. So what we've got in here is typical with an apartment building under construction, where we've got all the fire-rated walls that separate all the apartments.
David Blackett has been a building certifier in New South Wales for 25 years. He says the problem is not the certifiers, it's the system.
So often there is a perception that the certifier is like the policeman on site. Is that accurate? And if not, why not?
No, absolutely not. The frequency of site attendance is governed by legislation. Now, if we stick to minimum legislative requirements, we are on site 5% of the construction program, right, if that. Right, we're here for absolute milestone inspections only, so to suggest that we are policing the project couldn't be any further inaccurate. The certifiers under New South Wales legislation...
The law says certifiers are only required to check a fraction of these important safety devices called fire dampers, designed to prevent fire spreading through a building.
In a building of this size, what are we, 5-6 levels, there could literally be hundreds and hundreds of fire dampers penetrating the walls. So... And
you're only required to check one
per floor.
10.
One per floor.
Okay. That seems crazy.
If I have 300, I check one, 299 escape our door. So Sean, what we're looking at here is an apartment bathroom, an ensuite.
The same applies to the waterproofing of bathrooms.
We're required to look at, certifiers in New South Wales, we're required to look at 10% only per floor. 100 bathrooms, 10 bathrooms only we're required to look at. But when we come out, we're looking at a membrane on a floor. We have no knowledge of how many coats have gone down, we've got no knowledge of how it was installed, and we've certainly got no knowledge of what happens to that floor after we walk away from the site.
Certifiers approve most construction work by relying on tradespeople and engineers saying they've done the job properly.
None of that paperwork carries any legal recognition. They're not legal documents. In some instances, they could be written on a beer coaster because they carry no recognition in the statutory process. The only one document that carries the legal recognition is our occupation certificate. If something was to fail or go wrong down the track, it's the occupation certificate that's brought to the table, and it's the issuance or the author of the occupation certificate who is in the firing line.
And that's you.
And that's me.
A spectacular example of alleged poor certification of buildings is currently playing out in the Northern Territory.
Later this month, a structural engineer is set to face an inquiry into alleged professional misconduct after 9 multi-storey buildings in Darwin and Palmerston were deemed to be non-compliant.
A government audit of the engineer's work showed the buildings he approved failed to meet the national construction standards. If found guilty, he faces deregistration in the Northern Territory, but that wouldn't stop him from practicing in other states.
The trouble at the moment is almost anybody in Australia can claim to be an engineer. Other than in Queensland, where there's been a registration system in place since 1930, in other states and jurisdictions there is no restriction on anybody claiming to be an engineer. We regard that as being unacceptable, and I think the community regards us being unacceptable.
Tonight, a 30-storey Sydney apartment building is evacuated amid fears it could collapse.
Last Christmas Eve, Opal Tower residents in Sydney were forced out of their apartments after major cracking. The building was less than a year old.
I was thinking Australia is, very good in regulation stuff, but it was very shocked for me.
An independent investigation found the damage was caused by changes to the original design. The report said it could have been avoided with a registry of engineers to ensure high standards, and regular inspections of the design by another independent engineer.
That expert report identified that one of the critical factors to the problems in that building was it was not built as designed. So the people who are constructing that building made changes to the design, presumably not knowing the impact of those changes. What they were doing was going to fundamentally alter the functioning of the building.
Another major problem contributing to defects is the use of poor quality building products.
There's structural steelwork that's substandard. There's been problems with asbestos contamination of fibre cement boards in various hospitals around the country. There's also a concern now about lead and lead contamination of plumbing products. There's glass which is substandard, balconies that have exploded and fallen to the street in Melbourne. We've got the flammable cladding issue.
It's a Tuesday morning and inspectors from the Queensland Building and Construction Commission, or QBCC, are heading to a Brisbane building site.
Thanks for your time. It's just one of the Queensland Building Commission's programs. We do random site inspections, and we'd just like to just have a quick come on site, have a look at your floor plans, whatever the private certifier signed off, and then go for a walk. If you've got time.
Yeah, absolutely. We might get you signed in and we'll go for a walk.
All right, thank you.
The QBCC has broad powers to police building sites. One of its key roles is to crack down on a major issue in the industry: dangerous products. This site gets the all clear.
One of the key reasons that the Queensland Parliament gave us this power is to make sure that if you are bringing a product into Queensland and then putting it on a building site, that it is safe, that it meets the requisite standards, and that people can have confidence in the built environment in Queensland.
Queensland's law is designed to ensure that every person involved in a building can be held legally responsible for the products they use.
It imposed a duty of care on all of the people in the building supply chain to ensure that it wasn't just the building surveyor at the end of the process that had the duty, it was actually everybody. Which means that you can't then, as an architect, turn around and say, it wasn't my fault, or the builder, it wasn't my fault, because you now have a duty to actually make sure it actually is your responsibility. So that was, it's a fundamental change in the way that building governance and building regulation is supposed to happen and should happen.
The Queensland law was supposed to be a model for the whole country.
In 2017, New South Wales was set to follow Queensland with its own building products law. The industry was shown a draft bill, but when it got to Parliament, it had been watered down. The reason? Four Corners has confirmed Cabinet was worried more regulation could slow down the construction business.
We were shocked because the whole thing had been heavily edited, and we counted up about 80 clauses that had been pulled out of the documentation, and those clauses were all around non-conforming building products. In fact, the definition of a non-conforming building product wasn't even in the bill. All of the clauses to do with chain of responsibility and duty of care, they were all taken out, as were all powers, the recall powers the Minister had to recall defective products. So all of the things that actually would make the bill a chain of responsibility bill were gone.
So it had been gutted.
Gutted, absolutely gutted. And so the industry, we were appalled. And so when New South Wales failed to do that, the other states and territories went cold on the whole idea.
Well, good afternoon.
When Australia's building ministers met in Sydney in July, there was a growing sense of crisis.
What we need to do is rebuild confidence in Australia's building and construction sector.
But they'd known about the problems for years.
People have been jumping up and down about this for years and years and years. You know, I've spoken to a lot of people in the industry that have been really concerned about the nature of building defects in this country. and there's been lots of committees formed, there's been lots of task force, there's been lots of consideration around this, but really nothing has happened.
17 months before the July meeting, they'd been handed a major report by lawyer Bronwyn Weir and former public servant Peter Shergold.
One of the tasks we were asked to do was to consider other reports, and essentially what our report does is draw the threads together of other very eminent experts who've told governments that these issues are occurring in the sector. That's why our report is so concise, because it was so obvious looking at a range of reports what the key themes were. So people have been saying these things for a long, long time.
It's not until, as we've seen people exit their properties, have to be out on the streets basically, does this start to come to the attention of the government or governments.
The building ministers finally agreed to implement the report's recommendations, including a crackdown on private certifiers and registering everyone involved in the building process.
The states and territories have committed to nationally consistent outcomes. That's what industry has been calling for. They've got the key recommendations from the Shergold-Weir report, and if they don't act, I think that they will rightfully deserve and get the wrath of the Australian public.
So it's very important that as our governments work through these issues, they do give it priority. It doesn't just disappear from the headlines and therefore disappear from policymakers' focus, and that we do get those recommendations in. It's important, obviously, for all those people who are living in apartments or are looking to purchase apartments, but it's also important for an industry which provides hundreds of thousands of jobs for the Australian economy at a time when we need those jobs.
If the states and territories implemented all of your recommendations in your report today, what's the legacy that we're still left with in terms of buildings that have been constructed over the last 20 years?
The existing building stock is what it is. We have hundreds of thousands of apartments that have been built across the country over the last 2-3 decades. Probably the prevalence of non-compliance has been particularly bad, I would say, in the last, say, 15 to 20 years. It's gotten worse over that period, and that means there's a lot of existing building stock that has defects in it, and we've heard many reports of owners dealing with those challenges. That can't be fixed by reforms in our, responding to our recommendations.
Would you buy a new apartment today?
I wouldn't buy a newly built apartment, no. I'd be, if I was going to be investing in an apartment, I'd buy an older one.
The drama of Mascot Towers has forced governments to act on the national defects issue, but that's little comfort for residents.
We received an email on a Monday night saying that our building was moving in a downward motion and it would be better if we moved all of our furniture out. It conjured up images of the building sinking.
Rosalind Lean is living in a serviced apartment partly paid for by the New South Wales government. She's allowed into the building on restricted days to water her plants. This week, owners expect an engineer's report to reveal what's wrong with the building.
My worst fear would be that if we can't move back at all or we're out for much longer, what are we going to do financially? I don't know how this is going to go. That's my worst fear, not knowing how long we'll be out of our apartment and the financial situation it's going to put on all of us. So that's my worst fear.
Close to 140,000 apartments are currently planned or being built across the country. The lesson from this crisis is buyer beware.
For me personally, I would not buy a brand new apartment ever again. I think for me, this has done the damage for me. I don't want to go through this again.
Don't buy an apartment. I just can't say you don't know what you're walking into anymore with this going on everywhere. You're really rolling the dice now.
Any comments on that? Dramatic. Yeah. I mean, I watched that. Most of the time, if I watch something I've watched, I don't want to watch it again. But that to me is really hits home. I made a couple of notes. Who's responsible for it? Because I'll tell you what's going to happen. Everyone's going to point the finger at somebody else. No doubt about it. We can talk about the council, we can talk about the contractors, we can talk about the subbies, we can talk about the engineers, we can talk about the lawyers, we can talk about everybody else. And where were the unions who are on site, who will stop a site like that if they see a problem in nothing? The guy's getting paid. Now I'm not blaming them, by the way, I'm just raising it. I'm putting a lawyer hat on, because lawyers sue everybody. They do. Everybody. If something happens, they sprint it in far and wide in the hope that somebody will pay. Or that everybody gets together and says, I'll pay a certain amount, you pay a certain amount, let's just get rid of this. And then government's got a lot to answer for. So who pays? You've got to feel for the people, don't you? I mean, don't you? Don't you? They have bought this, the hard-earned money, they're paying their mortgages on it. Because the bank says, you owe us money and you have to pay. Because they don't have a heart and soul. And hey, they've got to look after their shareholders. Poorly built, problem starts with the developer, they use a big name architect, then get rid of them. They then get somebody else to do the work. I put here design and construct. So they get the subbies to do something. Not everyone, by the way. You can have two buildings, two high-rise, same design, same builder, but one is infinitely better finished than the other. Look at the project manager. Because if they've got a good project manager who's really, really hard on them, it'll be a good building. If you've got a project manager that's just in a go, I'll make some money out of this one, and don't care, then the quality's not going to be the same. No builder's warranty. Nobody tells people that. There's no builder's warranty. Where were the lawyers in this, acting for the people that were buying? Saying, by the way, if you buy one of these, there's no builder's warranty. Good luck, because the only way you can claim against a builder is if they're dead or they've gone broke. But there is none. There's no builder's warranty, so you're on your own, buyer. And by the way, you paid a price that's not market value. You paid a price that incorporates the builder's profit margin, because it's not open to market forces. It's controlled by financial advisors. some sort, whether it's major or minor. Major or minor. You build a brand new home, you use the best equipment, the best material, the best architect, the best builder. Guess what? The ground moves. The ground moves. And when you say to somebody, by the way, there's a drought, go and water your house. I think you're mad. You need to water around the house to keep the soil moist. If there's too much rain, well, the ground becomes a little bit unstable. So there's a whole lot of issues. Mentioned the engineers, the lawyers, the planning. Now I've got my lawyer's hat back on. Remember we talked towards foreseeability? Because you see, they said 5 to 10 years to sue for major defects. Now, I'm not sure about that. There is a statute of limitations for stuff. And so no matter when they become aware of it, that you take action, you might just find a friendly judge that will say, I'll give you the right to do it. I don't know. But you've got to feel for people. Foreseeability. Engineers, there is case law. There is case law that says build it, engineer, everybody associated with it, you owe a duty of care, not just the person you got the contract with, but subsequent builders if something happens down the track and they become aware of it. If this ever ends up in a courtroom, and it probably will, I'm guessing you're going to find a judge that will be very, very sympathetic. Very sympathetic. And all they need is one little thing to find in favour for people that are aggrieved. Insurance premiums will go up dramatically because the engineers PI insurance will have to cough up. Somebody else's insurance company will have to cough up. The state government has already said they will put aside at this stage $600,000 in Victoria for cladding. Sounds good. I was talking to a mate of mine. He sells off the plan stuff. He is a genius at it. He is a genius at it. If Pete can't sell something off the plan, no one can. He lives in an apartment that he sold a whole lot of them off the plan. He bought one, he moved into it. In Bay Street, Port Melbourne. He's got magnificent views. When I was talking to him last week, he's another tragic St Kilda supporter, and we're talking football, as you do, or as we do. He was upset because the local council drove by and they think that there are certain parts of that building with flammable cladding on it. They have to spend $20,000 to establish whether or not the cladding is flammable or potentially flammable, and then work out getting it repaired, replaced. His comment to me was, well, the government said they'll put it aside, Bill, but if everybody makes a claim at the same time, they ain't going to have the money. So if we don't get it fixed and then make a claim against the state government, then the council might turn around and say everybody out. So we're going to get a report. We're then all going to have to cough up money and then probably battle the state government to get the cost of it. Good luck, Pete. See the issues? It's never so simple. You can write stuff. Notice Craig, by the way. Craig knew about the problems. He sold his apartment 5 years ago. Who's the bull plug? That said, yeah, I sold out about 5 years ago. How do you feel? Oh, pretty good. Pretty good. What about the people he sold to? He had knowledge, I hope that was in any documentation that was in New South Wales, that he actually said to the potential buyer, hey, by the way, there are issues with this. Because if he didn't, Craig's looking at being sued. Because if I was the buyer, having watched that, I would have been to my lawyers. In fact, I the real estate agent that sold that for him, they would have probably known about the defect too. I wonder if they said anything to the buyer. Stay tuned for the next episode. This thing ain't going to go away, alright? See you next week. But I just thought that was worth watching. That's it. We're not getting into the building industry.
But if I've got a draft, should I send it to by email or?
Yeah, email it.
Okay, cool.
Email it to my IINet address.
Yeah,
okay,
yeah.
it's,
Yeah,
I mean, I won't mark it, but I'll just say yes, you're on the right track or you're not.
Yeah, cool. Okay.
All right?
Thank you very much.
Pleasure. Till next week. Start again. You're looking to buy or do you want to sell?
I'm doing a research.
Oh, you're doing the research?
For my other courses.
Yeah.
So I'm doing a research on the market and I wish to see, to have a look of the customer preference over the market, see the price and the relationship between the bedroom and something like that, and then trying to work out the relationship to see whether there is a ranking among the developers as well.
No, there's not.
No.
No, there's not. You would
Not
find
for reputation.
reputation, right? Yeah.
Yeah, because I've searched online and I find that there is one developer ranking, but that one
No,
is only by size.
you won't. Having said that, and I'm just trying to think who did Docklands. What's the name, please? It's terrible. Mine's gone blank.